Hello and happy 2022, everyone. My name is Danny Jovico. This is my first YouTube cast of a channel for a new platform called IMREAL.LIFE, and this platform will encompass much of the work that I and my colleagues have been doing over the last few years. But we'll start off with FLAST, which is Family Law Australia Support and Training. FLAST has been around for a number of years and is there to help people involved in family law matters. We release almost daily digest of cases coming out of the courts, although since the merger of the family court there's been a lot fewer cases that are being published, so we're finding it the volume of cases to be coming through in dribs and drabs. In the meantime, we've selected one case to sort of review here today, and this is an interesting interim order that's being appealed. In this particular case, a father is appealing interim orders for the mother's supervised time with the children. So you read that right. The mother has been granted supervised visits and the father's not happy. He's appealing that decision. Interim orders were made for the child to spend supervised time with the mother at a contact centre. So you'd think that, this should be a no-brainer and the father would be pretty much happy with that kind of a decision. But no, he is not, and he wants the mother to have no time at all with her child. The court, in resolving the dispute, assessed whether the judge weighed up the risks to the child and balanced those risks and any ameliorating factors. Ameliorating is something bad or unsatisfactory made better. So we'll find out why that's a relevant issue here. Those factors weighed against the child's right to a meaningful relationship with the mother. This is the nature of this case. The parties were in a relationship for a little over 2 years, and during that time a child was born, and the child lived with the mother until he was aged 6 years of age. So the whole time he's lived with mum. And what's happened is mum has got involved with drugs and alcohol, so she's had incidents of intoxication and being drug affected in her behaviour, which has resulted in hospitalisation and police becoming involved. So that adversely impacted on the child's welfare, of course. And what happened next is interesting, that the mother's mother, so the grandmother, obviously had care or time with her grandson, and during that time placed the child in the care of the father. And that resulted in the mother having a psychotic episode. That psychotic episode led to her abducting and assaulting the maternal grandmother, and she ended up in custody for 6 months over that incident. In the meantime, on the 19th of April of 2018, the father applied for and the court made interim orders for the father to have sole parental responsibility, the child to live with him, and for the mother to be restrained from coming within 100 metres of the child. So, quite strong orders there. The orders were made for telephone communication between the child and the mother to be as agreed between the parties. As we often see when there's such orders, when agreement doesn't take place, then there is no communication, and that's exactly what's happened here. No such communication occurred due to the father's refusal to agree. After the 6th of January, the child didn't see the mother again until the 22nd of October 2019. So you got all of January, all of 2018 since from January and up till almost the end of October 2019. So almost 2 years that the mother didn't see her son. And the one time, or the next contact she had, was in the presence of Dr. B, who happens to be the court expert report writer in the parenting proceedings. So after 2 years of not seeing her son, her first contact was during the time that the expert report writer was making their report. Subsequently to that meeting, the child had not spent any time with the mother since 2019 up until, well, at least we're looking at 2021. So, we're looking now, 3 years plus that the mother has not had contact. So at that time, Professor D, a psychiatrist, diagnosed the mother with postpartum psychosis, post-traumatic stress disorder, persistent depressive disorder, separation anxiety disorder, and alcohol use disorder. So she's been diagnosed with a host of mental health related issues there. He recommended that the mother's criminal charges be dealt with under the Mental Health Act rather than going through the criminal system. So this custody for 6 months here was not under the criminal justice system, but under the Mental Health Act of New South Wales. And Dr. B, in his capacity as single expert, recommended that the child spend supervised time with the mother. So the court report writer did actually make that recommendation that the supervised time with the mother commence. The primary judge concluded that the risk to the child had been minimised and considered the child's right to be given an opportunity to have a relationship with his mother, and for that relationship to commence in a safe space like a contact centre. Her Honour found that the mother should not, on an interim basis, spend unsupervised time with the child. So it was supervised time that was ordered at the contact centre. And the father was not happy. He appealed. And we'll go through the issues here. The issue in this case, in the appeal, is whether or not a meaningful relationship with the mother would be an advantage to the child. So the applicable law here that we're referring to is the Family Law Act, Part 7, 60B, which refers to the court's obligation to ensure that the best interests of the child are met. Also 60cc came into it, which provides for the primary considerations with the court must be in considering and determining the best interests of the child. So as I said, this is an appeal case, and when we're looking at appeal cases, we have to understand what is the hurdle to overcome to have a successful appeal. So you can see that the case law relied upon, these are all High Court judgments dating back from 1936 up to 2003. So another judgment here in 2016. So, but all High Court judgments that we're dealing with here. And that they're the precedents that have a binding effect on the court today to when they're making decisions. So when you lodge an appeal, we have to look at what is the hurdle that you've got to overcome. It provides that the proper exercise of discretion in parenting orders may be broad, and it is a mistake to think that there is always only one right answer to the question of what the best interests of a child require. So the first thing is that the father here has to understand that even if he proves to the court that perhaps another judge could have made a different decision, it won't be enough to make that to prove that. What he has to actually prove is that the judge was wrong in the decision. So, and in proving that, not only does he have to prove that the judge was wrong, but the judge has to be plainly wrong in the decision, and that being no proper exercise of his judicial discretion. So it means that the burden of proof here against the primary judge is a very high burden. You can't just show that another judge could have said, made a different decision that was more favourable to the husband. That won't be enough. The judge has got to be proven wrong, and plainly wrong, so much so that it would not be a proper exercise of judicial discretion to make the decision that he did. In House versus the King, that provides that if the judge acts upon the wrong principle or allows extraneous or irrelevant matters to guide or affect him, if he mistakes the facts, if he does not take into account some material consideration, then his determination should be reviewed, and the appellate court can now substitute the decision and make good and remedy the error that was made. But to get to that point in time, you can see that the burden of proof is quite high on the father. And we'll keep going here and have a look at the analysis of this case and see what happened in the original decision, and is there any scope for the father to win this one. But at this point in time, we know that the burden of proof is going to be really high in terms of getting this appeal forward. The primary judge understood that the father was seeking an order that the child spend no time with the mother on both an interim and final basis. So it means there was no mistake here. The judge knew that the father didn't want the mother to have any time at all. And the evidence from the child's treating psychologist was that the child presented with symptoms and behavior consistent with childhood trauma, and that the mother posed a risk to the child's psychological welfare. So this is the father's case. This is the father's argument that in his care the child is safe and well, and that the mother poses a risk to the welfare of the child. However, on the mother's side, she had evidence from her psychologist as to her improving mental health and positive progress, and that was recognized by the primary judge. The primary judge noted that the child's wishes to see the mother, but didn't hold that as a determinative factor. So, we have a situation where the child actually wants to spend some time with the mother as well, although that wasn't the reason for the decision. The primary judge indicated that she was making a determination as to the child's best interests on the basis of the competing risks assessed by her and the evidence going to any amelioration of those risks. Her Honour considered the evidence of the father about the impact and that contact with the mother would have with the child, and weighed that in the evidence. So this whole appeal, the fathers need to prove that the judge made a wrong decision, a plainly wrong decision, that was not a proper exercise of his judicial discretion. And so far, looking on the analysis and the facts, we're not even close. The primary judge indicated that she was making that determination as to the child's best interests. Her Honour considered the evidence of the father and the impact. The judge referred to the father's assertion that in 2020, the child's behaviour had changed and the child become more anxious as a consequence of having telephone communication with mum. Her Honour gave significant weight to the evidence which was presented to the court by the father, together with the child's school reports, which were contained in the father's tender bundle. And those school reports attested that the child was making excellent progress at school after being at a very low base when in the mother's care. So, the father has a strong case as to, when the mother had an alcohol problem, had a drug problem, and was having those mental health issues that she was facing, that the child indeed was not doing well. The question here is that enough to now, essentially ban her for life from her child? and weighing up of those matters and risks against the benefits of the child pursuing a meaningful relationship with the mother within a structure that ameliorated, that mitigated those risks if that was possible. That was the very basis for the decision that any time spent between the child and the mother was required to be supervised by a professional agency. So, no surprise in this decision, the court dismissed the amended notice of appeal, and the father was ordered to even pay the independent children's lawyer's costs of the appeal, fixed in the sum of $43.56. So, given that there's no surprise here, well, let's have a look at this case. In FLAST, you see wherever we've got these blue things, these are all hyperlinks. So this is a hyperlink to the actual judgment itself. So if I click on that, that should open up in Ausly. And we can have a look. Okay, so counsel for the appellant, the barrister, Miss Gillies SC, senior counsel, represented the husband, and the solicitor for the father, and the solicitor for the father, Santo Family Lawyers. So one has to wonder, given the case law that exists and the hurdle that would have to be overcome to win this appeal, how was the father advised by Miss Gillies senior counsel and Santo Family Lawyers to pursue this matter? The mother in this case was represented by legal aid. So you have legal aid going up against actually quite formidable opponents here. And I say that because you're looking at an SC here, senior counsel. So if we get that SC and we search Google for her, what we will see is that Miss M.A. Gillies SC, barrister for the New South Wales Bar Association. If we click on that link there, she's been admitted as a lawyer in 1995, admitted to the bar in 2001, so was a barrister since 2001, and appointed senior counsel in 2017. You're talking about a very experienced senior counsel here, and how the father was advised by senior counsel and Santo Family Lawyers. Let's take a look at who these guys are. And Santo Family Lawyers, Santo Family Lawyers. Here we go. Santo Family Lawyers. About. So Carla Santo, the principal of Santo Family Lawyers, over 10 years of experience in family law and accredited by the Law Society. Again, an experienced solicitor here, and despite that, we've got an argument run on appeal that really, one wonders, was there any prospect of success to begin with? Anyway, look, this is my first cast for 2022. I hope everyone enjoyed this, and don't forget to like and subscribe, and I look forward to seeing the comments down below, and through the social media posts that we will share this this video clip with. Happy New Year everyone, and see you soon. Thank you.